Negotiable Instruments Act, Section 134, Law governing liability of maker, acceptor or indusser of foreign instrument. Section 134 of the Negotiable Instruments Act, 1881 lays down the rules for determining the law applicable to liabilities arising from foreign negotiable instruments and provides that, unless otherwise agreed, the liability of the maker or drawer is governed by the law of the place where the instrument was made. The liability of the acceptor and indusser is governed by the law of the place where the instrument is payable, making the section an important rule of private international law for foreign negotiable instruments. 1. Meaning of foreign instrument. A foreign instrument is a promissory note, bill of exchange, or check connected with more than one country, such as one drawn in one country and payable in another, commonly arising in international trade and cross-border transactions. 2. Purpose of Section 134. The object of Section 134 is to determine the law applicable to liabilities arising under foreign negotiable instruments and to avoid uncertainty in international transactions. The provision facilitates international commerce, determines the rights and obligations of parties, resolves conflicts between legal systems, and establishes clear connecting principles for liability. 3. Absence of contract to the contrary. The section begins with the phrase "in the absence of a contract to the contrary," meaning that parties may agree on a different governing law and the statutory rules apply only where no such agreement exists, thereby recognizing party autonomy in commercial transactions. 4. Liability of maker or drawer. The section provides that the liability of the maker of a promissory note or the drawer of a bill of exchange or check is governed by the law of the place where the instrument was made or drawn. Accordingly, the maker's liability is determined by the law of the country where the note was made, while the drawer's liability is governed by the law of the place where the bill or check was drawn. 5. Reason for applying law of place of making. The law of the place where the instrument was made governs the liability of the maker or drawer because the obligation is undertaken and originates at that place. Since the contractual relationship begins where the instrument is executed, the law connects the liability of the maker or drawer with that place. 6. Liability of acceptor and indusser. The section provides that the liability of the acceptor and indusser is governed by the law of the place where the instrument is payable, which is distinct from the rule applicable to the maker or drawer. 7. Liability of acceptor. The acceptor of a bill of exchange, who undertakes primary liability to pay it at maturity at the specified place, is governed in respect of such liability by the law of that place. 8. Liability of indusser. An indusser, who transfers the instrument and undertakes liability towards subsequent holders, is governed in respect of such liability by the law of the place where the instrument is payable. 9. Importance of place of payment. The place of payment is significant because the instrument is intended to be honored there, performance occurs there, and commercial expectations are connected with it, so the law links the liability of acceptors and indussers to that place. 10. Essential matters governed by applicable law. The applicable law determines essential matters such as the nature and extent of liability, rights and obligations of parties, conditions of enforceability, available defenses, and measure of damages or compensation, thereby substantially affecting the legal rights arising from the instrument. For more details, contact us.